Welcome everyone to the quarterfinals and congratulations on making it here. Please ensure for the competitors that you're muted while you're submitting. Judges, of course, may unmute themselves or keep themselves unmuted throughout the round. I'll be giving you visual time signals as well. So in this round here, you have 12 minutes. So I'll be giving you a 3-minute warning like this at the 9-minute signal, and a 1-minute signal at the 11-minute signal. And at 12 minutes, I'll be verbally saying time and showing you a signal as well. Please ensure, of course, that all of your notifications on your computer and your phone are turned silent. And please do not, as we know at this point, do not inform the judges of the schools that you are affiliated with. Please note that we may take pictures throughout the round as well for the social media purposes. And unless there are any questions for me, we can go ahead and get started once the justices are prepared.
Yes, are all the justices all ready?
I'm ready.
Okay, thanks. If you can begin.
Thank you, Justice. Before I begin, I would just like to confirm that my sound and positioning of the camera is acceptable to the court. Okay, thank you.
Looks good to me.
Okay, thank you. Good morning, Chief Justice and honorable members of the court. My name is Trang, initial J, and I am accompanied by my co-counsel, Aladina, initial S. Before I begin, I would like to first acknowledge and give respect to the land on which I present today, the territory of the Mississaugas of the Credit First Nations. We rise on behalf of the appellant, Her Majesty the Queen, in the case at bar. Would your justices require a brief summary of the facts?
No, not on my end. Any of the justices?
No, thank you.
Thank you. Continue on.
Okay, thank you. The appellant requests that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. The appellant has 3 submissions to make before the court today. Our first submission is that a member of an Aboriginal collective located outside of Canada does not qualify as Aboriginal Peoples of Canada under Section 35(1) of the Constitution Act 1982. Our second submission is that Mr. Desautel cannot establish continuity as per the Van der Peet test. And our third submission is that there is a real threat to Canadian sovereignty if the constitutional protections of Section 35(1) are extended to include Aboriginal peoples outside of Canada, as well as the appellant's proposed remedy in the case at bar. I'll be addressing the first submission today, and my co-counsel will address the last 2. Members of the court, this case is about reconciling the relationship between Aboriginal and non-Aboriginal Canadians who have lived and participated together as full and equal members of Canadian society. This is not about any other Aboriginal groups who are located outside of our borders. As agreed upon at the Supreme Court of Canada level, to determine whether Mr. Desautel has established the continuity element of the Van der Peet test, it is first necessary to answer the threshold question: whether or not an Aboriginal group whose members are neither Canadian citizens nor residents can fall within the meaning of Aboriginal Peoples of Canada under Section 35(1) of the Constitution Act 1982. We are in agreement with the lower courts that have established Section 35(1) must be interpreted purposively, but it must be done in a manner with the proper context of Section 35(1) in mind and not extend the meaning beyond its intended purpose. We submit that upon a purposive interpretation of Section 35(1), the words Aboriginal Peoples of Canada may only include the modern-day successors of Indigenous groups currently located inside of Canada, not members who are not and have never been residents or citizens of Canada. As the court has previously acknowledged in the Queen and Pally, Section 35(1) rights may only be exercised by virtue of an individual's ancestrally based connection to the present community. Any other interpretation would be inconsistent with this previous finding at the Supreme Court of Canada. This will be further established with an analysis of the linguistic, philosophic, and historical wording of Section 35(1). As the Supreme Court of Canada has established, interpretation of the Constitution must begin with the language of the provision in question, as each word in the Constitution is chosen for a reason and given a specific meaning. The legislature avoids tautology, and words are not used solely for rhetorical or aesthetic effect.
Counsel, I'm going to stop you there because you're certainly right that there are principles of statutory interpretation to be followed, but also the jurisprudence in Van der Peet and Sparrow tells us that we must take a liberal and expansive interpretation when it comes to Aboriginal rights. How can we simply rely on the letter of the law when the jurisprudence says otherwise?
Yes, Justice, it is true that in Vanderpeet and Sparrow, they say a generous and liberal interpretation is required, but we submit that, as the lower court noted in Vanderpeet as well, that Aboriginal rights are only to be held by Aboriginal members of Canadian society. So this requires a residence or citizenship requirement.
Counsel, in section 35.1, does it say when defining Aboriginal peoples of Canada that citizenship or residence is a requirement? Is it a bar?
No, Justice. It does not say specifically they must be citizens or residents, but we are interpreting today that the words Aboriginal peoples of Canada specifically does mean that it requires residency or citizenship.
And so let's break it down. So you mentioned linguistic factor is the first one. So what is that linguistic factor that points in favor of your argument?
Yes, Justice. So when we look at the phrase of Canada, one might argue that it refers to a place of dwelling, but we submit that this is incorrect due to the fact that the phrase of Canada can have a variety of meanings, as of can express an array of relationships, not just a place where one dwells.
So would that mean that you're then in agreement that the linguistic factor really goes both ways? Because, and that's the problem that I was having with the dissent's position, is it is in no way clear to me that of Canada also has a geographic component. Of Canada can mean, you know, let's say my family has French ancestry, you know, like it's, you know, an ancestry of France. It could equally derive to say coming from, as opposed to simply located in. And so you'd agree then that the linguistic side doesn't really help your argument.
Respectfully, Justice, yes, the wording of can go either way in the case at bar, but we submit that because of Canada has been used multiple times throughout the entire Constitution, such as citizen of Canada, government of Canada, and official languages of Canada.
And it is interesting that you raised the citizen of Canada as an example, because I would submit that that does not have any geographic component whatsoever, insofar as you could go back 3-4 generations of people that have never actually set foot inside of Canada who could still be citizens, insofar as citizenship can come through your parentage, i.e. where your family is from, even if your, say, mother and father haven't lived in Canada since they were 1 year old, or maybe never lived there at all. And so I don't think that assists you either, insofar as of Canada is clearly being used ambiguously when it comes to the citizenship context.
Yes, Justice, we do understand that one could be a citizen of Canada without ever stepping foot in this country, but we submit today that if we were to allow Mr. Desautel to be considered a Canadian citizen or resident as an Aboriginal person of Canada, my co-counsel will further explain that the variety.
Counsel, I don't think that's what the court is being asked to do today. What we're being asked is to consider whether Mr. Desautel has a right. The court's not going to grant him Canadian citizenship. And again, according to Vanderpeet, where we have the elements established, we're required to find that there is, in fact, a right to be claimed. Is that not so?
Yes, Justice, we are looking today at if Mr. Desautel can claim this right, but as I mentioned earlier, this is the threshold question that must be answered first to determine if the wording Aboriginal peoples of Canada does pertain to him, and we submit that it can only pertain to him if he were a resident or citizen of Canada.
But then let's put a hypothetical here. Let's take a person who resides in British Columbia and is a status Indigenous person, and they leave British Columbia and they become an American resident. Do they lose their rights under the Canadian Constitution? So this person is no longer a resident of Canada or of British Columbia. Do they retain their rights under the Constitution?
Yes, Justice. Just to clarify, in this hypothetical, when they become an American citizen, are they still keeping their Canadian citizenship too?
I'm playing with you a little bit, Counsel, because it actually doesn't matter. Their indigeneity, their Indigenous identity is not abrogated simply by the place where they live. They'd be able to claim the right regardless. So what I'm saying is, I don't think anywhere in the jurisprudence and anywhere in the actual wording of the act, it does say that residency or citizenship is a bar, doesn't it?
While it doesn't explicitly exclude Aboriginal peoples outside of Canada who aren't citizens or residents, we submit that the drafting history of the legislation should be taken into account in order to see what the drafters' intentions were. And we submit that the minutes of proceedings regarding the patriation of Canada's constitution is one that is notable to consider, as it involved Aboriginal representatives who all share the same understanding that
So you just stated that there should be the legislative history of Section 35 considered. Isn't it my understanding that there was resistance from the Canadian government to not include reference to Aboriginal peoples in Section 35 or their treaty rights? There was some debate. There were some protests happening around that time. And the Indigenous communities had much resistance around certain wording in there. So it was almost as if Canada didn't want Aboriginal considerations to be included in there. So I'm a bit concerned that you're just repeating what has done in the past with your argument.
Yes, Justice. While we acknowledge that Canada may have done so to try and exclude these Aboriginal peoples in the discussion, when we submit that the minutes of proceedings discussion did not do so because they did include a variety of Aboriginal representatives, such as one of the representative for the Inuit Committee on National Issues, Mary Simon, and she stated upon a proposed Aboriginal rights and freedoms provisions that the Constitution, Section 35, can only provide for Canada's 3 groups of Indigenous peoples. So that would include the present day ones, the Indian, Inuit, and the Métis.
Right,
but at the same time, that's the input of one person in what ended up being a significant constitutional convention. And so I don't think that would be determinative. And subsequently also, wouldn't it one need to, in terms of having a developing constitution, if we look at back in the history, Trudeau in the 1980s was pro-residential schools. And so to that end, shouldn't the constitution be able to evolve to better encompass Aboriginal rights?
Yes, Justice, we acknowledge that our rights and the Constitution can evolve, but we submit that when we're looking specifically at the Constitution Act 1982 and when it was created, we acknowledge that the discussion did not involve representatives of all Indigenous groups, but they did include wording such as Canadian in Canada synonymously with of Canada to imply that residency and citizenship is necessary. Honorable Justice of the Court, it is clear that Section 35(1) of the Constitution Act of 1982 was never meant to include Aboriginal peoples located outside of Canada who are neither Canadian citizens nor residents. We cannot broaden the constitutional protections of Section 35(1) to those that have never lived or resided in this country, as this would be a devastation to Indigenous groups who are currently inside of our country. Sorry. I see that my time has elapsed. May I conclude with just one sentence?
Sure, if it's one sentence.
Yeah, it will be one sentence. Thank you. For these reasons, we ask that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. Barring any further questions, my co-counsel will now address the last 2 submissions. Thank you.
Thank you.
Thank you.
Justices, before I begin with my submission, I would just like to apologize and inform you that I will not be able to stand up. I do have an accessibility accommodation, if that's okay.
That's all right.
Thank you. Good morning, honorable justices of the court. My name is Alidina initial S, and I rise to conclude submissions on behalf of the appellant, Her Majesty the Queen, in the case at bar. Before I begin, I would like to first acknowledge and give respect to the lands in which I present today, including the territories of the Wendat, the Anishinaabe nations, and the Haudenosaunee Confederacy. The appellant's second submission is that Mr. Desautel cannot establish continuity as per the Vanderpeet test. And our third submission is that there are very real and significant threats to Canada's sovereignty by extending the constitutional protections of 35(1) to include Aboriginal groups located outside of Canada, and that the appellant's proposed remedy is to enter a verdict of guilty on both counts contrary to the Wildlife Act and remit the matter to the trial court for sentencing. Justices, it is the appellant's position that the Vanderpeet test for an Aboriginal right under Section 35(1) is not satisfied in this case because the trial judge committed a reviewable error in her application of the Vanderpeet analysis, finding that the continuity requirement of the test was met. While the appellant does concede that an unbroken chain of continuity is not required, we do submit that the flexibility of the interpretation of continuity has its limits. And in the case at bar, the limitation that has been crossed is one of a lack of evidence. The only evidence offered at trial about the Lakes tribe's presence at all before 2010 was a singular event in 1972, when Charlie Quintiskit, a Lakes Indian from the Colville Reservation, walked into the office of Aboriginal scholar Dr. Dorothy Kennedy. Not only does this evidence that the lower courts have presented have no legal significance, but it also bears no relevance.
Counsel, I got to stop you there because it does have legal significance. The jurisprudence that we have before us in Vanderpeet and Sparrow clearly states that we have to be quite liberal in interpreting evidence of both Aboriginal land claims and Aboriginal rights claims simply because of the nature of Indigenous history. They are oral tradition keepers. They don't maintain business records in the same way that a colonial justice system would expect them to.
Absolutely.
So do we not? So when you say it's not of legal significance, do we not have to include these in our deliberation as the jurisprudence says?
Absolutely. If I may refer you to paragraph 39 of Mitchell, the Vanderpeet approach does not operate to amplify the cogency of evidence adduced in support of an Aboriginal claim. Placing due weight on the Aboriginal perspective or ensuring it's supporting evidence in equal footing with more familiar Western forms of evidence means precisely what these phrases suggest: equal and due treatment. While the evidence presented by Aboriginal claimants like Mr. Desautel should not be undervalued, neither should they be artificially strained to carry more weight than they can reasonably support.
Okay, but now, sorry, go ahead, Justice Salat.
Thank you. I was just going to ask. So when you say that you're placing artificially strained concerns on it and you're placing undue weight, how do we determine what is undue weight or what is equal weight rather? Is there a case law that you're referring to when you say, or a test that you're referring to when you say that there should be equal ground that you're considering this at? Because otherwise, aren't we just going to automatically consider the colonial justice system before we consider anything else?
The appellant's position is that the single shot that Mr. Desautel fired cannot create the Lakes tribe's modern exercise of the right. And in the absence of even minimally cogent evidence, this conclusion is inescapable. Now,
but counsel, I don't agree with that because we have in the trial record the original decision by the original trial judge. He heard the evidence. He is a trained jurist as we are and is familiar with the provisions, and he decided that it was sufficient. And so what authority do we have as an appellate court to overturn a finding of fact by the trial judge who heard the evidence firsthand?
Absolutely. While the trial judge is stated to be the best person situated to assess the evidence before them, the appellant's position is that the facts as she found them do not meet the continuity requirement necessary to establish the Aboriginal right. This court should and can be expected to right the wrongs of the lower courts. And the appellant's position is that they are within their right to assess that.
But if I may, isn't your argument essentially assuming that 1982 is the key year for finding this Aboriginal right? Whereas how would that be consistent with a reading of Section 35 in conjunction with Section 25 that clearly establishes that it's not Section 35 isn't creating any rights. It's merely essentially recognizing rights that already exist. And so how would...
I'm sorry,
Chief Justice, you're muted.
Yes, how would you work it in to be able to say that 1982 is a determinative year and really even important for the continuity analysis?
The appellant's position is that the 1982 Constitution did not create Aboriginal rights, but we cannot explain, and the lower courts have still not been able to explain the Lakes Tribe's absence since 1982 up until 2010, a period of almost 30 years.
I mean, and that's like one of the areas that you're indicating that there is no evidence, but the trial judge clearly considered two relevant factors for why they were not there. One of them being the creation of the border, the second being the Game Protection Amendment Act.
Absolutely.
That literally made it illegal for them to continue exercising a right that was established to have been present at the time of contact.
Absolutely. However, the trial judge also held that the Sinaiks had continued to hunt in British Columbia up until the 1930s, despite the international border and despite the passing of the 1896 British Columbia Game Protection Amendment Act. And for that reason, it cannot be said that either of these pieces of legislation prevented the Sinaiks from hunting.
I mean, at the end of the day, then, is it the appellant's position that the tribes, in order to be able to keep exercising the right, had to violate a law that shouldn't have been passed in the first place? And so far as specifically the Game Protection Amendment Act is a provincial legislation, it shouldn't have applied to Indigenous peoples at all under the Constitution Act of 1867. And so are you saying that they need to be violating the law constantly in order to maintain the continuity element? And how is that consistent with the honor of the Crown as well?
Absolutely not. The appellant's position is not that the Sinaiks and the Lakes Tribe should have continued to violate Canadian laws, but that the abandonment of the rights has served to make the continuity requirement of the Vanderpeet analysis void.
So
Counsel, sorry, go ahead.
Go ahead, that's okay.
Counsel, what are we to make of the role of the colonial state in this? Because it's very convenient for the state to claim, well, they abandoned the right, when it was direct action by the Canadian government that forced this group to abandon this territory and be south of what is now the border. They also, took steps to restrict hunting, to restrict tribal practices, to eradicate oral traditions, etc. Do we not have to, in the spirit of reconciliation, fix, or I should say redress some of these issues when present? How can we ignore that?
And also, before you answer that, because it's related, two parts. One, what you said about the equal and undue weight, how does that then not fall in undue weight in favor of the colonial justice system is one piece. And the second piece is, are we not then asking for an Aboriginal right to be lost or abandoned simply because of non-use? Non-use that was caused and put into place by Canadian laws.
If I may address Justice Phillips' question first. While we cannot deny these colloquial borders, the effects of colonialism that we have had on our Indigenous peoples, on Aboriginal peoples of Canada, we cannot deny the importance of our borders in today's day and age. We cannot deny the importance of residency and citizenship. And for that reason, to side with our friends would be to turn a blind eye to the fact that Canada is a sovereign nation and that we must look after and protect those who live, work, and feel the full burden of our law. And my apologies, Justice Saylad, would you be able to just repeat your question?
Of course. So my question is it your position, is it the appellant's position that it is fair for us to be asked to hold that an Aboriginal right be lost and abandoned simply because of non-use, and non-use that was imposed upon them by Canadian law?
Justice, the Lakes Tribe engaged in the practice of hunting in Washington state during this time as well. And so it was just non-use in Canada. And for that reason, we are submitting that it is an abandonment of practice in Canada. And for that, and that's why the territory has been, in the appellant's position, abandoned.
So even if we do accept that, why can we not consider Mr. Desautel's hunting as the first, step to try and reconnect the chain? Because we know that, there can be a lapse of time, which the appellants also conceded to. So if we can have this lapse of time, why can't we accept Mr. Desautel's hunting as that first step to reconnect the chain?
We cannot accept Mr. Desautel's single shot to create the modern exercise of the right. And I see my time is elapsing. May I briefly answer your question and conclude? Thank you. We cannot accept that Mr. Desautel's single shot has created the modern exercise of the right, because for a period of 30 years, 80 years, my apologies, from the 1930s, these rights were abandoned. The land was abandoned in 1956. And the appellant's position is that this is too long. And the abandonment of rights, the abandonment of practice, has significance in the case at bar as well. Now, if I may briefly conclude, honorable justices, it is the appellant's position that while we cannot deny the importance and the protections of our nation's borders, we must look after and protect those who live and work and feel the full burden of our law, our Aboriginal peoples of Canada. My colleague has elaborated why Mr. Desautel is not an Aboriginal person of Canada. May I just briefly conclude my sentence?
Yeah, I'm okay with that.
Thank you. And the consequences of not following this position stretch far and wide. Barring any further questions, the appellant rests.
Thank you.
Are the justices all ready?
Yes, on my end. Yes. Thank you.
Okay. Before I begin, I would like to ask if my audio and my video is sufficient for the judges today.
Yes, counsel.
Yes, thank you.
And good morning, honorable justices of the court. My name is Kay Ferrer, and I'm here today with my co-counsel, William Igbokwe, as counsel for the respondent, Mr. Desautel. We request, respectfully, that the Supreme Court of Lions Cup uphold the lower court's ruling in exempting Mr. Desautel from the Wildlife Act provisions under which he was charged and dismiss the appeal. The respondent has 3 submissions under this request. First, I will submit that Section 35 protects modern-day successors of Aboriginal peoples of Canada, which now includes Aboriginals located outside of Canada. My co-counsel will then submit that a geographical component does not preclude the application of the Vanderpeet test for Aboriginal claimants residing inside and outside of Canada. My co-counsel will also submit that the trial judge did not err in finding continuity and properly considers the evolutionary element of the Vanderpeet test. Honorable justices of the court, this is not a case about a foreign rights holder group asserting their rights in Canada. This is a case about whether a person of Indigenous ancestry who is not a Canadian citizen or resident is entitled to exercise their Aboriginal right in their people's ancestral territory in Canada. My friends propose taking a purposive analysis that takes a look specifically at the written language of the Constitution. Respectfully, Your Honors, it is the respondent's position that that is a narrow interpretation of a purposive of the Constitution. If I may guide you to paragraph 40 of the Queen and Blay, It states that recall that the charter was not enacted in a vacuum and must therefore be placed in its proper linguistic, philosophic, and historical context, as my friends are proposing here today. However, I would urge this court to look a little bit further and note that it states that Justice Dixon was speaking of the charter, but his words apply equally to the task of interpreting the natural resource trade agreements, which was the issue in the case of the Queen and Blay. It is the respondent's position that interpreting Section 35 similarly to the Charter and the NRTA is a narrow scope. The Constitution requires a completely different interpretive analysis and interpretive exercise. We must do so in such a light that maintains the purposes, the true purposes of Section 35, which is to recognize the prior occupation of Canada by organized and autonomous societies, and to reconcile the modern day existence of Aboriginals in our Canadian society and in light of the Crown's assertion of sovereignty. The Constitution was created to elevate Aboriginal rights. If we limit Section 35 to groups within Canada, we would not be partaking in reconciliation. There is this idea that Canada is a mosaic and we have different peoples, as we can see here today. There's a lot of different people from different areas. If we were to tell one person here that they could not compete, that they could not be in Lions Cup simply because they don't live in Toronto.
Counselor, I'm going to stop you because whereas I appreciate the philosophic implications of what you're talking about, what does this have to do with the man who shot an elk in British Columbia?
Yes, with Mr. Desautel, if we do not allow, who is an Aboriginal, Mr. Desautel, who is an Aboriginal, if we do not allow him to exercise his Aboriginal right to hunt for ceremonial purposes inside of Canada and limit Section 35 to groups within Canada, we would not be adhering to the purposes of recognition and reconciliation. The idea of the mosaic is to understand that there are a lot of different people in Canada, and we must understand that Aboriginals are a core of that mosaic. They were here before any of us were. The Sinixt people were here thousands of years before European colonizers came into Canada. And if we allow the appellant's position today, if we do not dismiss this appeal, we would not be allowing the administration of justice to adhere to the purposes of Section 35. Even more so, the appellant submits that requiring that the respondent submits that requiring a modern day successor group outside of Canada, that failing to allow them to seek refuge in Section 35 would fail to adhere to the Crown's obligation to respect Section 35's purpose of reconciliation.
Right, but Counsel, in respecting Section 35, we also have to consider the interests of Indigenous groups who are in Canada today, right now. And wouldn't allowing the appeal, wouldn't dismissing the appeal in this case open the floodgates? We would have potentially tens of thousands of Indigenous groups that are much more numerous in the United States than they are here, to make such claims, and as a result tie up our court system. Don't we have to consider that in making our determination today?
In terms of opening the floodgates, Mr. Desautel, as I mentioned, is a member of an Aboriginal group. Aboriginals do not see things the same way non-Aboriginals do. There is the idea of community and communal rights. And Aboriginals, at the end of the day, these are people from Sinixt territory who range from British Columbia all the way down to Washington. The idea is if we allow him to exercise his rights, he is essentially exercising in his Aboriginal territory. Does that answer your question?
I'm not sure that it does, because the issue of reconciling, right? So reconciling is to take two different positions and merge them. We do have to consider the burdens that it might place upon the justice system, as well as potential future outcomes that could come as a result of our decision here today. So maybe let me put it in a more concrete example. Let's say that Mr. Desautel was not asserting a right to hunt, but a right to mine. If there were mineral resources south in British Columbia, would this not complicate the picture enormously? Because we could have potentially thousands, as I said, of land claims that could result in commercial exploitation on Indigenous lands. And so that's the future implication of dismissing the appeal, which we're concerned about.
Yes, Honorable Justice, you raise a very valid point and concern in terms of allowing lots of other people to come in and claim Section 35 rights. However, the respondent is not submitting that just everybody come into Canada and claim their Section 35 rights. In our specific case today, Mr. Desautel, as a member of the Lakes Tribe Group, who is a modern day successor of the Sinixt people who were here thousands of years before any of us, he is a part of the Aboriginal peoples of Canada because Sinixt holds territory within Canada. If it were, say,
I think it may be more accurate to say they held, past tense, because the Lakes Reserve was deemed abandoned in 1956, and in 1935, only one person was there. And really, in 1900, only a couple dozen. It was really a very, very small community that's been present there for the last century. So it's difficult to assert the right in a modern day context when it's been probably abandoned for 3 generations, maybe 4, if I'm not mistaken.
Yes, Honorable Justice. In terms of held, the idea that it was held in past tense, I would like to bring up the example of the President of the Philippines and the President of Korea. When they refer to people of the Philippines or people of Korea, they do not refer simply to people within the borders. They refer to everybody who is Filipino or Korean. There are many people from the Philippines, from Korea, from Ireland, who are outside of the borders. I, for one, am Filipino and I live in Canada. I practice Filipino traditions. I take part in I eat with Filipino food. This does not mean that just because I'm in Canada that I'm not Filipino. And similarly, just because Mr. Desautel is a United States citizen does not mean that he's not Aboriginal. We must adhere to the purposes of Section 35 and allow other Aboriginals with the background of Aboriginal territory, the Sinixt people, with that background to claim Section 35 rights.
Counsel, are you saying that we should limit this only to folks who belong to certain Aboriginal groups that had, that have or had an ancestry in Canada? Because the case-by-case question and that in your response to that was that we shouldn't necessarily allow it in every situation, but we should allow it in the situation. Albeit that is your purpose, that is what you're trying to litigate here, but why does that help us determine why this case over other cases? Why not some other situation where another person of Aboriginal descent is seeking a right? And how do we determine then that?
Yes, Your Honor. In terms of determining how another Aboriginal can seek a right, we must, as I've mentioned, look at the phrase Aboriginals of Canada and interpret that in light of the purposes. As we cannot allow just anybody, as I've mentioned, you have to have the Aboriginals should have that background to Canada and be Aboriginal peoples of Canada, so much so that we don't open the floodgates, but still allow Aboriginal peoples of Canada to utilize the Constitution. If we don't do so, what would that say about, it would implicate a negative implication and put the administration of justice into disrepute if we do not allow Aboriginal peoples to be Aboriginal peoples.
Counsel, but just how far do those rights go? I mean, I thought in this case, we're talking about the fact that it was a traditional practice, but my concern here is when you're expanding the definition so far of Aboriginal peoples of Canada, as long as they've been here, as my co-justice stated, do they now have rights to mine because they were here before? Do they now have rights to fish? Or what exactly is the limitation here in terms of rights that can be claimed under 35?
Honorable Justice, if I may continue to answer the question. The rights that Aboriginal groups may claim in terms of Section 35 are the rights to do what Aboriginals do, to be who they are and maintain their identity. The idea of indigeneity and be allowed into Canada, into the land that they were here before us, the land that they took care of before European colonization, the colonizers came, and before the implications of colonization and the imposition of European laws happened.
Thank you, Counsel.
Thank you.
That's time. Thank you.
Can the justices hear me correctly and see me well?
Yes.
Thank you. Good afternoon, Honorable Justices of the Court, and good afternoon, my friends. My name is William Ibuki, and I'll be concluding the submissions on behalf of the respondent, Mr. Desautel. Your Honors, I will submit 2 submissions today, first of which, that a geographical component does not preclude the application of the Van der Peet test, and thus the Aboriginal claimants residing outside of Canada. And next, I will conclude, I will submit that the trial judge in applying the Van der Peet test did not err in her finding, as the trial judge properly considered the evolutionary principle as required by the Van der Peet decision. Your Honors, the jurisprudential history in investigating Aboriginal rights has stated specifically where such rights are to be legally operated. They, however, have not stated who such rights are, who in fact holds such rights. In fact, if Chief Justice Lamar stated in the Van der Peet decision that the affirmation and recognition of Aboriginal rights is in fact grounded in one fact, that prior to the arrival of Europeans, Aboriginal peoples were living here in their own communities. This was later echoed in the Mitchell decision when Chief Justice McLaughlin stated that prior to the arrival of Europeans, Aboriginal peoples were living in their own political and social structures. This ultimately speaks to the notion, as we submit here today, that Aboriginal peoples occupied and used their land in their own ways. And it is the right, and Section 35 recognizes this right that Aboriginal peoples across North America can hold. The purpose of the test, in fact, speaks to this particular notion. As stated in the Van der Peet decision, it is to identify the elements of these pre-existing societies that existed in North America. And in fact, prior to the contact of Europeans, we submit that it runs contrary to Section 35 and runs contrary to the test as delivered in the Van der Peet decision to narrow the possible recognition of Aboriginal rights to those exercised on Canadian geography, even before the borders were laid. We submit that neglecting this particular notion ultimately neglects the instance of displacement that was so prevalent during the colonization of North America. Your Honors, we ask the court here today to remember that, like all cultures, Aboriginal people across North America migrated due to instances such as war, famine. However, as the court recognized, as per paragraph 113 of the Van der Peet decision, the instance of European colonization increased its fluidity. And as Chief Justice Lamar stated, it introduce novel opportunities for Aboriginal communities, which some may say may have helped their traditions in some way or another. However, we submit as in general common sense that European colonization hindered to a great degree Aboriginal practices, and most importantly, it hindered their ability to continue their Aboriginal practices.
Right, but Counsel, but part of the exercise here is that we have to figure out the envelope in which all of this fits. So you're proposing expanding the envelope, but I think the court is particularly concerned about the practicalities of this. So for instance, if we recognize that there was a right to hunt, would it not also extend, for instance, the duty to consult, which is established in the Constitution as well, if there were to be construction or land development? And how far back does this go? Because this reserve was abandoned some 60 nearly years ago. And so let's say we wanted to then develop this land for the purposes of a highway or for mineral exploitation, let's say. would we not have to consult not just this group, but any group that might potentially have had a claim going back to the Royal Proclamation of 1760, which, as you might see, is a bit problematic?
Yes, Justice. We actually submit that as Chief Justice Justice Cote stated in the Desautel decision, that it would increase the amount of Aboriginal groups that would be needed to consult. However, that's an incorrect framing of the duty to consult. It is important to note, as stated in the decision, that Aboriginal communities, it is up to them to put the Crown on notice. If the Crown does not have relevant and substantial evidence that they are infringing on such rights, or they are, or any of that, at that case, it is the onus is on the Aboriginal claimant to put the Crown on notice.
Correct, so, but the issue is, once, if we decide to dismiss the appeal, it puts everyone, who is capable of reading Canadian jurisprudence on notice that we acknowledge the rights of people outside of our borders, and therefore it would encourage them to do exactly that. Is that not so?
Yeah, yes, Justice, and we submit that should not be seen as a negative impact on this decision. And in fact, as the court stated in the Haida decision, it is up to the consultation as a fair duty that leads to reconciliation. And as further stated in the Pali decision, the difficulty of identifying members should not be exaggerated to a point to the point of defeating the rights under Section 35.
Okay, that's fair. But getting back to maybe consultation, part of the issue here is that the Lakes Tribe didn't take part in a lot of consultation leading up to now. So for instance, for the Constitution Act, their representatives didn't participate at all in the consultations to form the Constitution in the first place, and don't seem to be terribly interested in participating in Canadian society or exercising Canadian rights until today. And one might argue that creates a dormancy of the right, that they weren't interested in claiming it until recently, and therefore we have to take that into account when making our deliberations.
Yes, Justice. However, we must also take into account the visit at Dr. Kennedy's office. My friends may state that during that such a gap, that abandonment has happened, and that in such an instance they forgotten their land. However, the evidence stated that the land was in fact maintained, and we must also take note of the visit at Dr. Kennedy's office. It was, as the member of the Lakes Tribe stated, they were inferring on why a native reserve was not in the Northern Territory. So we submit that to say that they did not try to exercise their rights, or they just abandoned their land, it speaks against the evidence. And even when you speak prior to the the office visits, we can look at the international and sub-governmental treaties that are put on them to stop them from hunting. And yes, we do submit, as the court in Desautel stated, that those treaties did not directly lead to the ceasing of their practice, like the 1930 onward interruption. However, the trial judge did state that there was a gradual decline in the Northern Territory. So taking this into account, we submit that it would only make sense for cross-border hunting to decrease as borders, or as the Canadian borders grew stronger. And we must also take into account the concept of evolution. When we compare the pre-existing society, when we look at the pre-existing society, we submit that they exercise such rights is because it was integral to their culture. As the court stated, it was, as the jurisprudence has stated, I believe in Vanderpee, it's not only for subsistence, it can be for maintaining their ceremonial purposes. So in light of that, when you're considering the continuity elements, we must show that they have demonstrated that purpose. So in this instance, we submit that in asking for the native reserve, they were demonstrating an integrality, a continuation of trying to facilitate their pre-contact rights.
But counsel, in the dissent, Justice Cote noted there's significant differences in the modern practice compared to the traditional. So the pre-contact practice was a ceremonial round of seasonal hunting that occurred within their territory. They're primarily located in the South, of course. And so, this has evolved. What has happened is one man has crossed the border and shot one elk. And I'm not sure that constitutes continuity with the pre-contact practice, which is an element under Vanderpreet.
Yes, Justice. Yes, Justice. I do take note of your notion there. However, if you don't mind, I would ask the court to draw attention to the paragraph 48 of the Sampler decision. It was stated that the associated cues of such cultures must be looked at in the analysis of the evolution, and this effectively considers the internal and external factors that have affected the practice through time. This is why the court rejected the Crown's assertion in the decision that large permanent dwellings constructed from multidimensional wood by modern methods is not a continuation of the pre-contact society or an application of the evolutionary principle. The court rejected this is because for instance, we cannot expect the community in this case here to continue to build their houses with the tools that they did thousands of years ago. And just like in this case here today, we cannot expect Mr. Desautel to do round seasonal trips back and forth across a border to maintain his subsistence and ceremonial purposes. One thing that we must take into account.
But the issue of counsel is not necessarily whether Mr. Desautel singularly did it, but it's whether members of his community did it. It's whether his parents might have done it, his grandparents, but really within probably the lifetime of all those individuals, there's no evidence that we have that this practice continued. So does that not abrogate his right in some way?
We submit that concluding that the absence has not continued does not take into account. Well, we submit, in fact, that the notion that it has not continued because other members have not practiced it, and that it was just him, negates the instance of colonization and displacement, and the fact that his tribe members, although they were not forced out by gunpoint, however, it was found that it was not voluntarily done. This was ultimately facilitated by the colonization of North America that drove them to the southern border, the southern side of their traditional territory. So in light of that, we submit that when we are categorizing these the Aboriginal claimants, we must remember that they are not returning to the Canadian side of the border. They're not returning to the, we can't even say that they're not returning to the northern or southern side, because that sort of implicates the border. We must state that they are just simply returning to their traditional territory. And when we implicate that this border, or that they're returning to their northern or southern side, this takes into account the geography, and this effectively considers geography before the application in the Vanderpreet test.
So, Counsel, I'd like to accept, for a moment. I'll just have you answer this, and then I think we can conclude. I'll accept what you said for a moment, and in doing so, I would just like you to help us understand how the modern right is demonstrably connected to the pre-contact practice, which is part of the Vanderpreet analysis. Just how do you establish that connection? That demonstrates.
If I may just briefly give one point. As for the Vanderpreet test, they must maintain integrality, and we must look at that flexibly. This is in bringing up the Dr. Kennedy's office meeting, they stated through oral history that they tried to maintain their land through the native reserve. We are not submitting here today that native reserves are representative of integrality because they are directly a source of colonization. However, that is the Aboriginals in this case have tried to amend, have tried to moderate. We're asking the court today to moderate just as how they have.
Thank you, Counsel.
Thank you.
Thank you all for your submissions. The justices will now deliberate. So if everyone, including the spectators and the competitors, but of course not the honorable justices, could kindly leave the room using the leave breakout room button at the bottom of the screen. You will not be permitted to re-enter, as of course we know there is no feedback during these elimination rounds, but please stay in the courthouse lobby for further announcement and advancement announcements, please. And thank you.
Thank you.
Thank you so much.
Okay, thank you.
Thank you, everyone.
Thank you.